Ok. Boa tarde a todos. Desculpa o nosso pequeno atraso, mas estamos começando, agora está tudo certinho. Eu sou a professora Ângela Kretschmann, advogada, pesquisadora na Universidade Federal do Paraná e da PUC. Estou aqui para moderar o painel sobre o tema autoria e titularidade. Eu vou intercalar um pouquinho o painel entre o inglês e o português, mas nós falaremos mais em inglês, né? Eu só gostaria de deixar alguns recados importantes sobre o painel. Primeiro, nós teremos a apresentação do painel do Dr. Hannon, e depois nós passaremos ao Dr. Ryan e depois a doutora Craig. As perguntas vocês deverão fazer após as apresentações. E então, nós também poderemos dialogar um pouquinho sobre os temas aqui, né? Para obterem os certificados, vocês só precisam se inscrever no evento do CODAIP, preenchendo todos os dados. E os certificados serão emitidos após o evento e poderão ser acessados tranquilamente online. Então, não se preocupem com isso. Por favor, as perguntas, se possível, façam em inglês, isso vai nos ajudar a evitar erros de interpretação também, né? Agradeço muito a audiência de todos aqui nesta tarde. Well, hi everyone. I am Angela Kretschmann, lawyer, researcher at Federal University of Curitiba, and I'm here to introduce you the panel Artificial Intelligence and the New World of Intellectual Property. First, I will give you some tips on how the panel works. Our first presentation will be held in English and so on, the others also, and we will open right after for the questions. To whom have questions, we ask to write here down in the chat in English, because it will facilitate our debate, if possible, yeah? Because it will save time and misinterpretations. So, to get the certificate, just register at the CODAIP event, filling all the data in. Certificates will be issued after the event and will be accessible online. On behalf of JEDI and the event organization, I'd like to say thanks to our speakers and thanks for the audience. Now I will introduce both our three speakers. First, Ryan Abbott, MD, JD, MTOM, PhD, is Professor of Law and Health Science at the University of Surrey School of Law, Adjunct Assistant Professor of Medicine at the David Geffen School of Medicine at UCLA, partner at Brown, Neri, Smith & Kahn, LLP, and a mediator and arbitrator with James Inc. He is the author of The Reasonable Robot, Artificial Intelligence and the Law, published in 2020 by Cambridge University Press. He has published widely on issues associated with life science and intellectual property in leading legal, medical, and scientific books and journals. And his research has been featured especially in the popular press, including in the Times of London, the New York Times, the Financial Times, and other media outlets involving time. Professor Abbott has worked as an expert for, among others, the United Kingdom Parliament and European Commission, the World Health Organization, and the World Intellectual Property Organization. He is a licensed physician and patent attorney in the United States and a solicitor advocate in England and Wales. Managing Intellectual Property magazine named him as one of the 50 most influential people in intellectual property in 2019 and again in 2021. He wrote a very famous book regarding AI, and we will have the opportunity here again to know better his ideas. I hope so. He will talk about authorship and ownership of IP in AI, news around the world. Then we have Dr. Carys Craig. She is an associate professor at Osgoode Hall Law School, York University in Toronto, Canada, where she is the academic director of the professional LLM program in intellectual property law. editor-in-chief of the Osgood Hall Law Journal, and recently served as Associate Dean, Research and Institutional Relations, a recipient of the Institute of International Education Outstanding Service Award and the President's University-wide Teaching Award. Dr. Craig teaches and publishes in the areas of copyright, trademarks, law, and technology and legal theory. She is the author of Copyright, Communications, and Culture Towards a Relational Theory of Copyright Law, Edward Elgar. Her award-winning scholarship has been cited with approval in several landmark copyright rulings by the Supreme Court of Canada, including most recently in SOCAN v. ESA 2022 SCC 30, regarding the principle of technological neutrality in copyright law. Dr. Craig holds an LLB first-class honors from the University of Edinburgh and LLM from Queen's University in Kingston, Ontario, and SJD from the University of Toronto. And then we will have Mr. Hannon. He serves as a patent attorney with the United States Patent and Trademark Office of Policy and International Affairs, OPIA. Mr. Hannon's portfolio encompasses standard essential patent issues, patent subject matter eligibility issues, policy issues relating to artificial intelligence, and policy issues relating to plant inventions. Prior to join OPAI, Mr. Hannon has held various roles in USPTO, including the Office of the Undersecretary and Director, the Office of the Solicitor, and Patent Operations. Well, we are very lucky to have these speakers here with us. Clearly, all of them are very busy, and it's not easy to put them all together, especially because they are from different countries and continents. And so the time zone sometimes is a problem. So let's start. Please, who are with us, remember, we will open for questions after all speeches. Now I ask to Mr. Hannon, please, you can start.
Great. Well, thank you so much, Dr. Kretschmann, for the introduction. And as you all heard, I'm an employee of the U.S. Patent and Trademark Office, but my remarks today will be strictly of my own and should not be attributed to the U.S. Patent and Trademark Office. Today, I'm going to be discussing the implications of AI on patent law specifically. And as an entry point to do this, primarily, we're going to get into what exactly is artificial intelligence, or AI, because it's a term that has a lot of ambiguity around it, and it's fraught for misinterpretation if we're not very clear about what it is that we're speaking about. And as policy regulators around the world have grappled with this issue, I'm going to share today three sort of prominent definitions that exist out there in policy realms. The first of which is from the Organization for Economic Cooperation and Development, which many of you likely are familiar with, is a policy group and intergovernmental organization that sort of drives policy issues for market-based economies. I'll talk about the US Congress's definition that was espoused back in 2019 through some legislation, and also turn to the EU's AI Act definition as well. So starting out here first, the OECD definition is really, I would argue, one of the broader definitions that we have today. So you can see here, it's an AI system which is machine-based, capable of influencing the environment by producing an output for a given set of objectives. It uses machine and/or human-based data and inputs to perceive real and/or virtual environments, extract these perceptions into models through analysis in an automated manner or manually, and use model inference to formulate options for outcomes. So this last sentence here, that AI systems are designed to operate with varying levels of autonomy, is, in my opinion, it's sort of a future-proofing mechanism that the OECD members put in here, because they're thinking about today we may have some level of autonomy that is more reliant on human interaction, but in the future, these types of AI systems could go much more autonomous, if not, akin to human interactions. The second definition here is a different approach. So this is the US Congress's approach back from the National Defense Authorization Act in 2019, which actually was partial to many other AI initiatives that the US was engaged in that legislation, but particularly in order to have any clarity about what they meant when they talked about AI, they had to actually have an attempt at defining it. And so the approach that the United States Congress took was to sort of make 5 different branches of definitions, if you will. So you can see the first one is any artificial system performing tasks under varying and unpredictable circumstances without significant human oversight, or that can learn from experience and improve performance when exposed to data sets. Again, the US here is defining this in terms of a system. In the second iteration here, developed in computer software or physical hardware to solve tasks requiring human-like perception. Then a third iteration, an artificial system designed to think or act like a human, including cognitive architectures and neural networks. Fourth, a set of techniques, including machine learning, and that's really important that we've said machine learning expressly here, I think, that is designed to approximate a cognitive task. And the last 5th one is an artificial system designed to act rationally, including an intelligent software agent or embodied robot that achieves. So now we're getting more into sort of what it could be in sort of a robotic sense in this last one. So 5 different definitions, all equally categorized as AI in the US. Now, I think the award for concision may go to the European Union here, because in their AI Act, what they've done again is defined not just AI, but an AI system, meaning software developed with one or more of the techniques and approaches listed in an annex, which you can see my note there, and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. And so again, going back to the comment about the OECD's attempt, I think, to future-proof the definition, the EU also did this in a mechanism whereby they have specific AI approaches, if we can call them that, in an annex, where they specifically list out things like machine learning, knowledge-based approaches, and statistical approaches. All right, so what can we learn from each of these prominent definitions that exist out there for policymakers? Well, I think, again, it's important to recognize that they didn't just try to define AI, because intelligence in and of itself, right? Just speaking of human-based intelligence, philosophers and very smart people have had a hard time, neurologists even, right, have a hard time grappling with what exactly is intelligence and defining that. So artificial intelligence is just necessarily more a complicated thing to define. So I think that goes some way as to why these policymakers have defined it in terms of systems, because then we have some sense of, okay, maybe it's computer hardware and computer software that's doing something of an AI nature, but we're more concerned with the fact that it's a system. So I think that's an important commonality amongst all 3 of these. Also, really important, I think in the past, there have been sort of waves of prominent AI technologies, right? So back in the 80s, a very prominent technology would have been a knowledge-based expert system or symbol-based system. Today, I think a lot of the venture capital goes towards machine learning systems. And so there's definitely subclasses underneath machine learning, but in the sort of the broadest sense, machine learning captures a lot of the breakthroughs that we've seen, and I'll touch on some of those. So I think it's really telling that policymakers were wise enough to explicitly pull machine learning into each of their definitions. Additionally, each of those definitions that I just shared with you suggests some level of human involvement. So either there's a human that's defining some objective for the algorithm to run. Even if it says, there's a minimal interaction, it still implies that there is some interaction or some oversight by a human being, or even, the fact that you have to take some human data point about what we're doing to actually make sense of that AI system. So there's still a tie-in in each of those definitions to how humans are involved with these AI systems. And going back to the point I made about how difficult it is just to define intelligence, my read of these definitions is that policymakers are they'll use the word human in some sense as a proxy for intelligence. So we don't have to define intelligence, but if it's something on par or akin to what a human being would do, that sort of gives some inference as to what level of intelligence we're speaking of when we define these systems. And equally, each references decisions as an output of such systems. So I think there's a lot of thought that's gone into this, but most artificial intelligence systems today really I think you could argue that they are in fact they're either a decision machine or they're a prediction machine. There's some system that's using linear algebra and a machine learning system that's reducing some set of inputs down into what it perceives, the algorithm perceives as the most likely outcome, or something that a human being would appreciate as a decision to make or a prediction to follow. So those are all in all three of those. I think those commonalities exist across all three of those. But in the EU and the US definition, I think it's important that they explicitly refer to software, because as we'll see when I get into some specific patent law issues, a lot of the matter that we deal with in software and the complexity of how do we treat software under patent eligibility law, especially in the US, how does that bear when we get into the AI context, and are those issues the same? I would argue they are. There's a lot of overlap in just plain old fashioned software and those issues that we see in AI today. So again, AI is an umbrella term, right? There's just not a lot of specificity in just mentioning AI. As I mentioned before, in the past, there's been these waves of technology that have come into favor and been the sort of the mode du jour for the time. Evolutionary algorithms, maybe they didn't have their great period in the limelight, but things like expert systems were very prominent in a lot of the 1980s-ish AI systems. But today, on the right side of the umbrella there, we're really talking about machine learning in most instances when we're hearing about AI advances in the news or from whatever blogs or wherever we're getting our information. But and under machine learning, so that's sort of the broadest moniker. You have then, neural networks or artificial neural networks, as you may hear them referred to. And then you've got deep learning as a subset of neural networks. And so that deep is implying that it's not like deep thought or deep cognition, like, oh, he's lost in deep thought. No, it's more about the architecture, the size of the nodes that are interconnected there in that architecture of a neural network. It's so big that they call it goes deep, right? It's a deep learning architecture. So, those are types of AI, I would say. So those AI systems, they can then be applied to various numbers of use cases. And so I think it's important when policymakers think and talk about artificial intelligence, they have to distinguish, the technology from the actual use. And so things like driverless vehicles may be enabled by some underpinnings of an AI algorithm. Obviously, there's been a lot of breakthroughs in natural language processing and all the applications that come through just being able to speak with a computer, with a machine, right? Having it understand you and equally being able to respond coherently to you. We've seen a lot of advances in robotics that are based on AI, as well as a lot of commercially marketable technologies like recommendations or advertising systems or anything of that nature, right? So those things are all probably based on some AI type algorithm, but they're not necessarily, I would argue, AI per se. They're uses of AI, if you want to speak of it. And so on this slide, you can see some of these great advances that are most recently in the news, right? And in my very technical scale of AI-ness there at the bottom, right? So on the left, you have things that maybe at one point in time, everyone was really blown out of the water and thought that these were really fascinating advances in AI, but they've become more and more integrated into our daily lives. They kind of lose that novelty appeal to things like biometric passwords, right? Using your fingerprint to log into your laptop or unlock your phone with your face. Email spam filtering, right? Everybody takes that for granted, perhaps, but it's largely driven by sophisticated AI algorithms. And all the digital voice assistants that we use, the communications that we have with our Alexas and Siris and whatever other devices that are out there, right? Versus, so those are they AI? Are they not AI? That's debatable maybe, but then you have things that are on the right side here that I think are squarely well understood to be cutting edge, most sophisticated high-tech applications of AI we have today, right? So Meta has their open pre-trained transformer that was trained on 175 billion parameters for language, for natural language processing. You probably saw recently there was a Google engineer that thought that the chatbot NLP that they had designed, Lambda, was somehow sentient. And this man was convinced that the machine had come to life and had a soul and whatnot. You had DeepMind with their AlphaFold technology, where we see such advances in sort of pharmaceutical research and protein structuring and modeling that is definitely going to advance medicines at a great clip here going forward. And then OpenAI as well, not only their GPT-3, which is another large language NLP type system, but you've got the DALL-E 2 architectures, which are really neat. You can play around with them online, where you can generate images based on the text, so the computer will come up with these new images. So definitely teasing some copyright issues there, perhaps. But there in the middle, I somewhat in jest, I have this here lies deep learning. So back in 2006, when that term was first coined, till some point in the future, there's a lot of researchers in the AI field that today are starting to make claims that deep learning is maybe the most advanced subset of machine learning that we have out there that underlies a lot of those things on the right here. That's probably not going to be the path in and of itself to sort of a generalized artificial intelligence that becomes akin to a human level intelligence. So we may be seeing new models, I would expect, in the very near future. So stay tuned for that. But I think there's starting to be a realization that just alone deep learning is not going to get us to this artificial general intelligence state. So now when we get specifically into patent law issues, I think it's really important to distinguish the impacts of 3 different fields of AI that we can term here, and how they're going to impact innovation or invention. And so the first is sort of what I've been talking about, right? It's these very fundamental building blocks, these algorithm structures that advance this computer science branch of artificial intelligence. And so the example I have here is of AlexNet. This was back in 2011, 2012. There was a ImageNet contest where you were scored basically how well your algorithm could differentiate images, right? So is it a cat or is it not a cat, right? And so AlexNet blew the competition out of the water at the time by scoring well above the past historical metrics. And so that architecture that they used and the hardware implementation, this is where we get into the graphics processing units, the GPUs that have come to prominence in machine learning and deep learning. This was sort of the beginning of that back in 2011, 2012. And so you can see that structure, the hardware implementation, that's going to be something that I would term a core AI, something that is really just the fundamental building block of the artificial intelligence system. Then you can talk about applied AI, and that would be those use cases that I mentioned before. If you have that AlexNet and you apply it specifically to recognizing, let's say, a human being's face for unlocking their phone, right? That could be a specific application of the AlexNet to some facial recognition application for phone security. And so if you're applying some generic structure, let's say at a certain point, right, you can use AlexNet and you can repurpose it, you can train it on different things. You will then become, some other discrete use for that particular building block. That's going to be an applied AI. And then third, you have what is maybe the most fascinating and the most interesting ramifications for patent law, and that is what we can term inventive AI. And that's going to be inventions that are output of an AI architecture. And so there's claims that there have been cross bristle brush toothbrushes designs. There's been antennas that have been designed. And so these things that are actually the output that don't really have anything to do, like a toothbrush, it's not high tech by any means, that I would argue at least. That's not really going to be anything to do with AI, but the important fact that it was generated through some sophisticated AI system or AI algorithm. And so we have to differentiate the level with which that tool has actually played into that innovative process. So once we can distinguish with these 3, with that background in mind, I'll turn to some discrete patent law issues that, just tease them here. I think I've probably got a couple minutes left, and then we can maybe pick them up through questions or later. But the first of which goes back to what I said before about how artificial intelligence is really, at its core, it's very much a subset of software generally, right? So we have a host of issues in the US. So this, of course, is the statute for the United States Code. Section 101 is our patent subject matter eligibility statute. On its face, very straightforward, but in judicial application, it's become the subject of a lot of ambiguity. And so we have one particular judicial exception that the Supreme Court has told us, and that goes to abstract ideas. And so abstract ideas has, sort of created a lot of issues in the certainty of issuance of patents that involve computers or software or hardware interactions. And so I think today we're still going to be grappling with that because AI is still a subset of that. And despite many attempts to get the Supreme Court to come back or have Congress enact some clarity, We're working on it, but we're still not there yet. So I think this is definitely an area to stay tuned to make sure that AI innovations, those core AI innovations, can really remain patent protected and incentivized. So I'm gonna skip over novelty if you're familiar with patent law and go from 101 not to 102 but to 103. I think a lot of the obviousness issues are maybe more interesting because 102 is novelty. That's just a one-to-one correlation. If something exists. But when we get into 103, now we're in this realm of inventive step, right? To what degree must your invention rise so that it actually is not just some routine toiling or something that is not really inventive, but it's really something that's so useful and groundbreaking now that it's non-obvious, that there was some inventive process that went on that give it a rise to something that no one of ordinary skill in the art would have understood. And so you've got some breakthrough things. So this is a subjective standard for sure. But I think the implications for AI here are going to be that when we have levels of skill in a particular field, if they're reliant on artificial intelligence systems, then that's definitely going to necessarily increase the bar for patentability, I would think, under 103. Take, for example, the AlphaFold or any sort of drug discovery tool that's AI-based today. I think once you see those in labs around the world, that's going to necessarily raise the bar for what is non-obvious, what is inventive for pharmaceutical compounds or any other field of technology, right? Because of course, there's going to be a host of applications for AI systems in the future, and so this will affect this legal construct that is the person having ordinary skill in the art. So if we all are sort of enabled and enhanced in a sense by some artificial intelligence system, then at some point patent examiners are likely going to have to account for that enhancement in the field of the level of skill in the art. So here I've got the inventorship statutes 115 and 116. I think this is a really interesting field because, like, excuse me, going back to the concept of inventive AI, if you have a machine, an AI system that can output things, you know, what is the effect of that? How do we deal with that and treat that on inventorship grounds? And so we've got our federal circuit ruling out there that's currently on appeal to say that, you know, under current statutes, you must have a human named inventor. So, but if there is some significant contribution from a machine, you know, to what effect is that? Will that stifle the ability of a human being to get a patent if they used an AI tool? And if we did ascribe inventorship to a machine or give it some joint inventorship status, I think there's some other issues that we're going to have to grapple with. For example, you know, we're going to have to rewrite our statutes on oath, or like an inventor's oath or declaration. So this is basically a statement that a human being signs today to say, yes, I am the true inventor of this thing. And if you have joint inventors, they would each submit their own oaths or declarations. And so obviously, unless it's a robot with a handwriting algorithm, you know, it's not going to be able to do this or digitally sign something somehow. So we're going to have to definitely rethink that. Equally, in sort of litigation, there's going to be a question of, you know, how, if you wanted to ask the inventing machine a question, you know, how would we facilitate that? Would they have to necessarily be some requirement to build in some NLP functionalities that the machine could give itself its algorithmic, you know, internal functioning somehow? So these are challenging issues to think through, but definitely that's what we're doing today. And, you know, also, if there is going to be that level of sharing between a human and a machine, you know, is that what we want to do? Is that the direction we go in to afford some joint inventor status? So today, under US law, at least, just designing a problem and then having a machine execute on it, case law would say that that's not enough for the human being to be the inventor as the designer of the problem. But you remember from those definitions, it was acknowledged that AI systems often, they receive some human oversight, they receive some defined objectives from a human being. So that this is going to play in there somehow. And then ultimately, if you did ascribe some rights in a machine, you know, the question of how would you vest those rights in the machine itself, and would they just sort of be go back to some guardian ad litem or some other legal construct to make sure that the rights are appropriately held in some fashion? So these are fascinating issues that we're actively dealing with today. So even beyond the patent law implications, I think there are innovation impacts that are really crucial and you know, require some serious deliberation and contemplation. And that is, you know, if if these AI tools, as we saw on that slide, with the number of AI breakthroughs in recent times, those are only held by a handful of companies, right? So if one of these AIs, let's say, the singularity ignites and these AI systems take off and they really become AGI, what is the effect of that? If one company owns that and we have this supreme intelligence, what impacts on society is that going to hold for us? Is that going to be good? Is that going to be bad? Will we need some tool to break that apart? Will there be competition issues there? And arguably, these issues would go far beyond patent law or competition law generally. Today, we've got some news out there that there are attempts at prior art generators. So these are AI systems that just generate inventions. And so I mean by that is that they're creating specifications of patents, basically, so that an examiner could use them. So if you got a tool that was really good at just generating specifications that a patent examiner could then rely on that to reject a human being's invention, is that, what is the effect of that, right? Is that going to stifle human invention, and do we want that to happen? Or even assume the ultimate state that I just mentioned, where you have an artificial general intelligence, right? Something akin to human intelligence, if not beyond that. And you can just tell it, hey, look, we've got climate change, we've got food shortages. Like, how do we deal with this machine? And the machine solves it, right? Do you even need a patent law at that point, right? If we get that sophisticated in our technology, after all, at least in the US, the underpinnings of the system, right, are to sort of incentivize inventors and authors. So do you need a patent system to do that if you have such an advanced technology that it alone can really solve all of humanity's issues? And so, I'll leave you all here with this image of, the Alexa versus HAL from Kubrick's 2001, two very different flavors of artificial intelligence. We've got the very brittle NLP technology that's based on Alexa today versus, in the movie, HAL has the ability to solve problems, find problems, compete with humans, and try to, in fact, kill a human being. But I think ultimately, the human wins in the end. If you haven't seen it, definitely, spoiler alert, go see it. The human wins, arguably. So I'll leave that there. And I think this is probably a good segue into Dr. Abbott's presentation. Thank you for your attention.
Thank you. Thank you so much, Mr. Hannon, for your so enlightening explanation of what AI is. And it is a lot of things. I think we can talk a lot more later with the questions. And I might say will be maybe a good sequence. It's up next, Dr. Ryan Abbott. Please, welcome.
Thank you very much. It's a pleasure to be back this year. Sorry we're not doing it in person, but I thought that was a great talk from Chris and did a lot of great ground laying. So I'll try and pick it up from there. By mentioning some of the really cool stuff that AI is doing now. And as you heard, it isn't necessarily that some of this stuff is necessarily new. We've had AI making creative and inventive stuff in whole or in part for a long time. It just wasn't very good at it. But really this year, we've seen a major breakthrough in things like text-to-image generators and their commercial usefulness. So here's a cover of a popular US magazine that the magazine said is AI generated and only took 20 seconds to make. It was a little misleading because people had to give it prompts and spent a while with that. But an AI made this, and now it's on a magazine cover. And last year, an AI could have made a cover. It just wouldn't have been quite as interesting. Not just AI creating new, traditionally creative works, but also doing inventive stuff. You heard a bit about this. This is a still shot from a video made by a team at Google describing how they built an AI based on machine learning that could automate chip floor planning. And chip floor planning is the process by which someone arranges components on a microchip. And that affects how the microchip functions, from how much electricity it uses to how quickly it performs. So those designs have a lot of value to companies like Intel that build microchips. And the team at Google said, well, it takes a team of people months to do this. It takes our AI less than 6 hours. And not only that, but on all the key performance indicators on how you would want a chip to function, the AI design chips outperformed the human design chips. So without this necessarily being an example of an inventive AI, it is an example of AI doing more in research and development. And when we think about things like autonomy, and Chris gave, I thought, a very helpful overview of the AI definitions, I take a more specific view of AI as really any technology that is, behaving as though it has cognition. Sometimes these are very simple programs, sometimes they're complex ones, sometimes they're based on rules very clearly made by people, sometimes they're based on machine learning. But the basic concept is you have a machine that is behaving the way that a person might behave. And it's not autonomous in the sense that a self-driving car woke up one morning and decided to start designing chip floor plans, right? It is very much a tool in the sense that it is built by people and it does what people tell it to do. But many of these systems are autonomous in the sense of completing specific tasks. So once you set up an AI like this, it just starts making chip floor plans. The people designing the system themselves may have really very little idea how to make chip floor plans. Or if you think about, for example, Deep Blue beating Garry Kasparov at chess, a group of people built that who couldn't have possibly beat Garry Kasparov, even if they were playing as a team. So AI can be both a tool and autonomous. And for our purposes, that has all sorts of interesting intellectual property implications. The industrial strategy implications of this have not been lost on jurisdictions around the world, which are constantly competing at putting out kind of cool looking industrial strategy plans to become AI superpowers. This was the UK's most recent one, and you can see based on the graphic that they mean business. Not just reports, though. The White House last month put out an AI Bill of Rights. These are non-binding criteria that they would like companies to follow, companies using and developing AI, things like having AI be fair and transparent and explainable and so forth. But not all just reports and guidances. The European Commission, of course, came out last year with draft AI regulations. These don't have much to do with AI and IP, but they do create the first major jurisdiction. Singapore was the first to come up with regulations specifically targeting AI use and development, outright prohibiting some uses of AI, subjecting other uses to an almost medical device-like compliance regime, and having a lower tier of obligations for less risky uses. But of course, there are plenty of AI and IP implications. It's become fashionable for IP offices to start looking into this. The most recent wave was USPTO putting out 2 requests for comments in 2019, I think, followed by a report saying not too much needed to change. The UK IPO did one the following year and said, well, actually, we think there's a number of things that are potentially problematic here, or at least significant challenges. They did a second consultation that wrapped up this year that focused on just 3 things: text and data mining exceptions to copyright infringement. And the UK IPO recommended that the UK adopt a very broad one as opposed to the European Union, which has a relatively narrow one. AI-generated inventions and patentability, and AI-generated works and copyright protection, both of which we'll come to shortly. And of course, because we live in a global trade-based society, particularly in the case of intellectual property that often easily crosses borders, there's important international implications to this. If you are training your AI on people's copywritten images, and that's okay in the UK, but not in Brazil, that has all sorts of interesting implications for where people build and use AI and where you can deploy models trained on copywritten material. If you have an AI-generated image like that Cosmopolitan magazine, which at the moment probably isn't protected in the US, but is protected in the UK, you have, again, a very interesting system where you only have IP protections in some jurisdictions. So WIPO has been leading a conversation on these issues. In theory, there may be a new international treaty on this at some point. In practice, that's a very slow process. And in the meantime, jurisdictions in the past couple of years have, as cases have increasingly emerged on these issues, have started going in different directions. I'm going to speak a little bit about copyright and a little bit about patents, and we don't have that much time, and I know Carys is going to do more copyright. But in brief, AI making stuff isn't a new claim. There are always people involved in some way, but this is a Soviet mainframe from the 1960s that Soviet researchers said was making music. And if you haven't heard the earlier music, it's really very, very bad. You'd listen to it once for the novelty of a machine making something, and then you'd move off it. But OpenAI, you heard a bit about DALL-E 2, which has also an open jukebox initiative, has trained machine learning algorithms based on the music of popular artists, and it can make music that sounds like popular artists make it. And it used to sound unintelligible, and a couple of years ago, it sounded not very good, but vaguely like it had been made by these people. And now it is at the point where Equity UK, which is a performing actors union in Britain, has launched a campaign to stop AI stealing the show, because the use of AI to do this has become so very prevalent in music and movie industries. And they're not worried that the robots are going to take over exactly, but they are worried that music and movie studios are going to use AI to copy the likeness and style of artists and then not pay them what they believe would be fair remuneration for that. So these are not futuristic concerns that people are having. These are concerns that people are having right now. And of course, if you have an AI that makes Katy Perry-like music, that raises all sorts of really fascinating copyright issues and all sorts of socially and commercially interesting issues, especially if you get music that even sounds, as good or better than Katy Perry music. Plus, AI can make music in real time, even personalized to you, to go along with things you were watching or games you were playing or exercise routines that you were engaging in. And so it may change how creative works are made and used in some really interesting ways. Just a little bit of the law on this, because I know this has been a fixture of prior conferences here. The US currently has no case on this. They have a Copyright Office policy that says there's a human authorship requirement, which says if you don't have a traditional human author, you can't get copyright protection. And they cite in support of that policy to the 1884 case of Burrow-Giles v. Cerrone involving this famous photograph of Oscar Wilde. And it was a case where the Supreme Court held that a photograph was eligible for copyright protection, even though it is not literally the writing of an author. And they held that really any tangible expression by which an idea in the mind of an author was given form or was, given form is eligible for protection. And the Copyright Office says, well, that doesn't include machines which don't have minds. There have been a couple cases on things kind of like AI-generated work. The leading one was a series of pictures taken by a monkey of itself. That case was ultimately dismissed, but based on the idea that animals couldn't bring lawsuits. And kind of amusingly enough, the court which tossed the case out and said animals can't bring lawsuits routinely hears lawsuits from animals because, of course, people are animals. So a lot of these concepts are linguistically confusing and philosophically confusing, not to mention legally confusing. Oh, and there's Naruto for anyone who wanted to see an adorable picture of the monkey, which took its own photograph. In the UK, the law is different. There's a statute that's been there since 1988, which says if a computer makes a work in the absence of a traditional human author, that work gets copyright protection. The UK IPO, in its recent consultation, essentially decided not to mess with that. There's been very little litigation on it for a few reasons. One is there isn't a lot of copyright litigation on subsistence of copyright in the UK, period. Second, even if you thought someone had a Katy Perry better like AI, there wouldn't be a lot of point to suing over the existence of copyright because the law makes it clear that there is copyright. But I think most importantly, up until really now, these works haven't had much commercial value. So who's going to sue over them? Well, me, I suppose. So as part of the Artificial Inventor project, which I'm going to get to, the name has now become a bit misleading. There's now also copyright involved. We filed a copyright registration for an AI-generated work. It's this image you see below. The Copyright Office decided not to register it. We filed a lawsuit in the district court in the DC circuit, and we are waiting. We are in the process of filing motions for summary judgment at the court. Not much has happened in this case yet. But again, the Copyright Office's position is if an AI makes a creative work, it cannot get copyright protection. We argue that this work should get copyright protection. And the reason for that is that the US Supreme Court has said on a number of occasions, while there are a lot of policy benefits possible from copyright, the reason we have it in the United States is to serve the public interest in promoting the generation and dissemination of works. And if that's the outcome you want, then that's an outcome you get with this, because of course the machines don't care about copyright, but OpenAI charges money to have people generate works. It's a complicated business model, in part because of the lack of copyright and a lot of legal uncertainty. At the moment, they charge people for computing cycles over a certain number, and then they license them the right to the work. But if we're moving into an age where people will use AI to make creative works, then that's something copyright should encourage. If, on the other hand, you were a jurisdiction like France that very much believes copyright only exists to protect the human rights of human authors or the moral rights of human authors, then you might not want a system like that. The US, of course, though, allows companies to be authors and has allowed that for over a century. In our submission, we noted that the AI was the author because it was the factual author, but that doesn't mean it has any legal rights. It is a piece of property. And so our claim is that anything made by the property is owned by the owner of the property. The same way if you had a 3D printer make a physical painting for you, you would own that. So you should own a digital image made by your creative AI. I've totally lost track of time now, but I'll just try and hurry it up on principle anyway. On the patent front, you heard about from Chris, so I could probably skip over this a bit more. This was a case Siemens presented at the WIPO conversation, with the green thing being a car suspension and the silver thing being an AI designed car suspension. And they decided they couldn't file for a patent on this because they couldn't find a human inventor. The engineers involved said it just came out of a machine. And so this at least is the pressing commercial problem. And this technology has moved very quickly. Large pharmaceutical companies, for example, have invested very heavily in this space in the past few years and are increasingly using AI to do drug discovery. And that isn't to say that every time someone uses an AI, you have an inventorship problem. Chris gave a few examples for how someone could be an inventor, finding a problem to be solved, but normally not that. Normally we know, well, we want a vaccine for COVID, we want a new car suspension, we want a better microchip, we just don't know how to design it. Sometimes programming an AI to solve a problem, but modernly, many companies are in the business of pre-training machine learning algorithms and licensing it to other people to use. And the people using the algorithms may be using them in ways that the people who program them may not know they're being used. So you might pre-train an AI to optimize industrial components. Someone else may go off to use that to make a car suspension. Under US law, at least, if you didn't conceive of all the claims in a patent, or at least one claim in a patent, you can't be an inventor for it. So that probably wouldn't work under US law, although there's other jurisdictions it might work. Finally, recognizing the value of an AI's output might do it. And if an AI says, well, here's 10 car suspensions, go build them, test them, find the best one, that seems to make someone an inventor. But if an AI says, someone else built me, you asked me to find a new car suspension, I've made 10 million of them, I've tested them all, and here's the one that's clearly the best. Hard to see anyone in there has made an inventive contribution, at least directly with respect to the inventive output. The AI itself gets different protections. So in part because there was a real lack of case law and clarity on this for stakeholders, and in part to promote a discussion on these issues, I lead a group of attorneys internationally in filing test cases on AI-generated inventions. We just printed a prototype of one of these inventions. This is a beverage container based on fractal geometry. I'm waiting for it to get shipped to me. They've told me not to drink from it, but I am planning to drink from it. But a design like this could improve robotic grip or transportation or heat transfer, given the fractal geometry of the container. We filed for these patents in the UK and in Europe, and they underwent successfully preliminary substantive examination. We then corrected the inventorship to note that the inventor, in fact, was an AI, although the owner of any property rights in it would be the owner of the AI. Here's the PCT filing. And then we've now sent it out to 18 jurisdictions. South Africa granted us a patent last year with the AI listed as the inventor and the AI's owner as the owner of the patent. Again, this wasn't a matter of giving a machine any rights. The machine isn't a legal person. In point of fact, though, inventors often don't have any legal rights, and most patents are owned by artificial persons in the form of corporations. Australia, 3 days later, the enlightened Justice Beach wrote a 41-page reasoned decision as to why under Australian patent law, an AI could be an inventor, and at least in our case, we had the clearest claim of entitlement. 5 of his colleagues reversed that decision several months ago. The Australian High Court is now deciding this month whether to take an appeal. In the UK, we had a split decision by the UK Court of Appeal. Justice Burst thought we ought to have gotten a patent. Justices Arnold and Liang disagreed with that. The Supreme Court in the UK has now agreed to hear the case. The hearing is tentatively scheduled for February of next year. And you heard from Chris that the Federal Circuit recently upheld the U.S. Patent Office's denial of the applications. They just denied an en banc petition. So the next step in this would be a petition to the Supreme Court. The U.S. and the UK Supreme Court, though, of course, take a very small number of cases, but we are planning to file a petition for that. And here the court basically said, well, an inventor is defined as an individual in the U.S. Patent Act, and that could only be a natural person. And, you know, it's a very interesting question. You know, it does depend a lot on the text of a patent act in a particular jurisdiction, none of which were written for this in mind. But the first thing the Federal Circuit did was go to the dictionary and say, well, the dictionary says that an individual is a person. And if you go to the second definition in the dictionary, it says an individual is a thing. And the list in which you're found in a dictionary really isn't a decisive factor. So it is interesting, you know, even textual analyses of these questions can be very complicated. There are some other things like an oath requirement, and I'd briefly hazard a guess at some of Chris's questions. You know, an AI wouldn't do an oath or a declaration, but there are a number of instances in the Patent Act and the USPTO manual where inventors can't or won't do oaths, and still a patent has to list the correct inventor. An AI obviously wouldn't give a deposition, but that isn't to say that there wouldn't be depositions. You would just be deposing the people involved in making and using the AI. And it may be that an AI is actually a lot more transparent as a subject for this sort of thing than a human inventor, who have all sorts of reasons to lie about things or not remember things, whereas what an AI did may be fairly well documented in its records. I think I've forgotten all the other points I was going to make about that, so we better move on in the interest of time. Germany, however, said, sorry, this is Europe. Europe said, well, an inventor has to be a natural person, but the owner of an AI can list himself as the owner, as the inventor on that basis, just by owning it. And you can even state in the patent specification that this is an AI-generated invention. So they have come up with or proposed this workaround. We have a divisional filed in the case. We'll see the outcome of that. And a German court has said, well, again, for us, an inventor has to be a natural person, but we also don't have any of these US, UK-like rules on inventorship. If you just name the person with the closest nexus to the invention, that's adequate for us. And you could even write in the patent specification, it's an AI-generated invention. The German Patent Office didn't like that. They're appealing it to the Supreme Court. Although it doesn't solve, you know, what might be for now the more practical challenging question of, well, if you have 1,000 people involved in making and using an AI, on what basis does someone have a close nexus? And Chris brought up the joint invention issue. As a practical matter, it won't matter so much if everyone's at Siemens. But if you have, for example, a collaboration between Microsoft and Novartis, and Microsoft is contributing an inventive AI, and Novartis is contributing a bunch of pharmacologists, it could have some real commercial implications. And I will end it there. Thank you.
Thank you very much, Dr. Hannon, Abbott. And here in Brazil, just yesterday, we have some news also about the patent, and later we can speak about. Okay, so we are going to next up is now Dr. Carys Craig. Please, welcome.
Thank you so much. And yeah, thank you to Professor Kretschmann for the invitation to participate today. I've really enjoyed listening to what Chris and Ryan have to say. My work is focused more specifically on copyright as such, and I know that the focus of this event is on new technologies in the public interest. So I'll say my work is focused on copyright and the public interest, and more specifically, the limits of copyright in the name of the public interest. And so I'm going to be talking about what should really be beyond the reach of copyright protection, both in terms of what goes into AI, the training data and inputs, which I'll get to at the end, and also what comes out, which is what we've heard a lot about already, these AI generated inputs. So that's going to be the focus of what I want to say, but I also want to touch a little bit on the sort of principle of technological neutrality as a guiding principle in the law, and what that means in my mind, and how that should help us to inform these policy debates around AI generated outputs. So AI is obviously a hot topic these days, and we hear an awful lot about it. It seems that rather than the sort of AI we were taught to fear in sci-fi movies of our childhood, in fact, artificial intelligence, we are told, comes to us as an inventor, as a creator, as opposed to a conqueror. And so, you know, we've heard that machine learning software has made it possible now to effectively generate new works and new things that have all of the external hallmarks of human innovation, or in the copyright context, original creative expression. As Anne-Marie Bridey put it back in 2012, we are moving into an era in which machine-generated works will be facially indistinguishable from works of human authorship. The machines appear to be creating works of art and music and literature, and we typically associate this kind of creativity with human authorship as such. There are lots of go-to examples. We've seen some already. Many of them will be familiar to the audience. We have the AI-generated portrait of Edmund Bellamy, which sold at Christie's auction house for $500,000, and we were told that signaled the arrival of AI-generated art on the world auction stage, at least. The art itself, as you can see, the portrait was not great. The person in the portrait lacked a nose, if we're honest about it. But also we've heard that AI-generated art has come on in leaps and bounds even since then. So certainly anyone who's played around with the most recent generation of text-to-image generators can attest to the creativity and the sort of impressive aesthetics of this new generation of AI-generated works, which are indeed threatening to upset the usual operations of the art world. Beyond the visual arts, we have examples in cinema. This sci-fi movie Sunspring, which placed in the top 10 in London's annual film festival back in 2016, was written by an AI which called itself Benjamin, and which was trained entirely on sci-fi screenplays from the 80s and 90s. The script was surreal and vaguely nonsensical, but nonetheless a movie it was. And there are many more examples that we do encounter increasingly just in our day-to-day lives. So basic sort of chatbots and machine-generated text. We have images, Google's Deep Dream AI selfies here on this slide. We have music, as Ryan was telling us about, AI-composed music playlists in the style of different artists. And of course, as with any wave of innovative activity, when there's commercial applications and money to be made, the question very quickly becomes, well, who owns this stuff and who gets to make that money? I think a more apt question, or the one that we should begin with at least, is whether anyone owns it. And in copyright law, that requires us to ask, is it authored? And who or what is the author? Does it need to be protected? And if so, why and to what extent? So as we've heard around the world, as things stand, autonomously generated AI works are often in many jurisdictions not considered to be copyrightable works. So in the US, there is this human authorship requirement, which I think is founded in pretty solid jurisprudence and also in public policy. And that has meant a sort of steady refusal to register works like this one. Then we have in Australia, in most of Europe, in Canada as well, the fact that copyright only attaches to original works of authorship has been taken to mean that they must originate from a human author, a natural person who has a sort of direct intellectual involvement in the resulting expression. Alas, that didn't stop Canada's Copyright Office from registering this AI-generated work recently as a work of joint authorship. So it was one with one human author and one co-author or joint author that was listed as an AI app. There's not really any good reason for people to jump the gun on this one in the midst of a copyright consultation on this very issue, no less, but we're waiting to see how that will resolve itself. In other jurisdictions, as we've heard, there are statutory provisions that deem authorship. So as part of a legal fiction, they're willing to assign authorship to a person who's responsible for making the arrangements that led to the generation of a computer-generated work. So it does seem clear with all of the activity and many of the projects as well that Ryan is leading that we're at this critical moment in the evolution of the law. All around the world, policymakers and lobbyists and corporations and litigants are turning their attention to this question and asking whether we should enact a similar statutory provision to ensure the protection of AI-generated works. And if we fail to do so, will we necessarily fall behind in this sort of global competition on AI and innovation? And I think then a step back then to the policy, that we're very much inclined to think that if something has value, if something is useful and a contribution to our culture or to knowledge or innovation, then that should produce a private entitlement, that somebody should own something. As Rochelle Dreyfus put it originally, if value then right, seems to be a kind of principled assumption, but it's not a principle that the US Copyright Act embraces. It's not a principle that serves the public interest or the public welfare necessarily. And so we should avoid thinking that just because something is valuable or something is worthwhile, that we have to assign a private right to it. The question we should begin with is whether and how copyright should adapt to the rise of AI, and whether we need to expand our intellectual property system to what people term catch up with this kind of innovation, or whether we're better off thinking about the limits of intellectual property and allowing, as I suggest, these works to remain in the public domain. Another kind of principled way to approach this question is to think more broadly about how the law should respond to the emergence of new or paradigm shifting technologies. And one of the terms we're used to thinking about here is that of technological neutrality. So the idea that we should be treating new technologies essentially the way that we have old technologies to maintain a kind of consistency in approach to future-proof the law against future technological changes. And so one school of thinking here, what I call formal technological neutrality, tends to think that we should just extend the law to apply to new technologies without any discrimination or differentiation. That if an activity is functionally equivalent in its effect, it produced a work that looks like an artistic work, then we should just treat it in the same way. And so the logic is that if AI-generated works are functionally equivalent to human-authored works, then we should treat them as such. And if the former would be protected by copyright, then so should be the latter. And I think it's just all too easy for us to assume that the law should just be expanding to cover these new innovations by analogy, right? And it's pretty convenient for those who stand to gain from that. But scholars have repeatedly warned, as technologies evolve, that with each new game-changing technology, it shouldn't be our assumption that the law simply expands. It certainly shouldn't be that the market incumbents, or those who stand to benefit economically, get to decide how the law reaches into the future. So instead, what I suggest in my work is a more substantive approach to tech neutrality, where we focus on the public interest, on the normative objectives of the law, and we approach new technologies with normative neutrality. We want to encourage the same public interest, the same public policy goals as technologies change. And so I suggest then, in the copyright context at least, that if our objective in the law is to encourage authorship, to encourage people to engage in creativity and the production of literary and dramatic and artistic works, and to foster this vibrant public domain, then we need to apply copyright now in a manner that consistently advances that purpose. And I suggest that that means requiring human authorship for copyright to vest in a work, because copyright is concerned with encouraging authorship and rewarding authors. And I get there by suggesting that AI is not and cannot be an author. So this is a paper that I co-wrote with Ian Kerr a few years ago now, called The Death of the AI Author. And Ian's work in the field of artificial intelligence, unfortunately, we lost him back in 2019, and he had made an enormous contribution thinking about artificial intelligence and all kinds of new technologies, and how we should understand them with, realistically and relationally and in social context. And so when Ian and I discussed this question about AI authorship and copyright law, his position was that, people were kind of misunderstanding what it is that the technology is actually doing when it creates these new works. And I thought that people were misunderstanding what authorship is and what copyright is really supposed to be protecting and why. And so what we argued in this paper is that thinking about the AI as an author is making a category mistake. The authors and AI are different, and AI is incapable of authorship. So we don't need to encourage AI creativity. We don't need to reward AI generation. So we know, and I'm going to explain this a little bit more, that we know that people are inclined to anthropomorphize robots, right? We're inclined to think about new technologies, AI, robots, as having kind of human attributes and emotions. We heard about how we respond to them talking to us as though they're a person, and we build a relationship with them. And this is very common in the cultural sphere, but it's also common amongst AI researchers. So there's this paper by Dan Proudfoot where she talks about how the AI researchers will say that Kismet, the robot here, is showing a happy expression or is showing surprise. And of course, she emphasizes it's not doing that at all. It's a representation of a smile or a representation of a gasp. It's not showing anything. It doesn't feel anything. But we use and we talk about it as though there's expression, as though there's expressive agency or intentionality. And there isn't intentionality. AI is computational. And so intentions and creativity and expression, they're not. And these are just ontologically different things. It seems like obvious to say, but at the same time, it's something that bears repeating because of our tendency to think of the AI as saying something, as expressing something. We have other examples of robots, Spot the dog, robots dancing. And people love to watch the robots do the mashed potatoes, and we talk about how the robots are dancing. But I'm suggesting to you that the robots are not dancing. The robots are programmed to move, and so they're moving in a certain way, but they're not engaged in dancing, because when they move to music, they're not doing anything different than when you take them into a crowd and let them point their weapons at human subjects. They're just moving the way they're programmed to move. And dancing is an expressive act. Dancing requires you to engage with the music, to try to express yourself, your emotions through movement to music. The robot is not doing that. Similarly, when machines, neural networks are trained on text and they write something like a screenplay, they're simply predicting the words that might be strung logically together into a sentence. It's tempting to read that sentence as though the AI is telling us something, but it's not. It neither knows, understands, nor appreciates the connotations of the word assemblage itself. Ryan Calo says, the box is gorged on data, but has no taste for meaning. And then I think, more than just humanizing or anthropomorphizing the AI, we tend to romanticize it as well, right? So we start thinking about it as doing something entirely novel and unique, something beyond the reach of humankind. And in doing that, we sort of overlook the vast quantities of human expression and culture that are being used to train the AI. The AI they're not islands, their outputs depend upon all of this human authoring, actions, interactions, creative processes, interpretations. But we tend too often to talk about the AI as though it's wholly independent, as though it's utterly original. And so I think we're attributing to it, again, this kind of creative capacity that it doesn't have, to the extent that, the picture I showed at the start, we see this often in one manifestation or the other. We're never quite sure which hand is the hand of God. But in some ways, the AI seems to become the ideal author, like the true independent originating entity. And the way that we speak about it and romanticize it and idealize it is leading us, I suggest, astray in how we make our policy decisions about what we should be doing in response to innovations in this field. AI, again, as I say, is incapable of authorship. It lacks expressive agency. It's not engaged in dialogue. It's not engaged in the creation of cultural meaning. And so my suggestion is that means that even if the works are facially indistinguishable from works of human authorship, we should not and we mustn't make the mistake of treating the AI as though it is an author or engaged in authorship, that this is a category mistake. And so that means that, of course, we could just create a legal system that deems authorship in the AI and proceed accordingly. The law is perfectly capable of adapting to do that. But if we're thinking about good copyright policy making, we have to begin by recognizing that these works are just fundamentally different in kind and in purpose. And so they fit differently within the copyright scheme. And this point actually extends far beyond copyright law. We'll be making the same kinds of mistakes, misallocating economic and legal resources, privileges, political power, if we apply our laws and we begin our policy debates by misattributing human attributes and intentionality and agency to AI, and thereby create economic gain for a few AI owners or creators. So I suggest that we need to exclude AI-generated works from copyright protection, leave them in the public domain, not because I don't appreciate it. This one here is a robot that I did not create, but I did give the text prompt to the AI generator, which also did not actually paint it or create it or express it. But it's a wonderful picture, I think, of a robot painting a picture. And so I see the value in it, but I don't think just because it has value that we have to attach a right to it. I think that we can ensure that copyright works can be freely used, shared in a vibrant public domain, that they can inspire other creators, that they can enrich our culture without being protected by copyright. And looking at the time, I'll just take a final minute to say that the same kind of logic can apply when we talk about AI's training inputs, the things that go into training it. The AI is no more a reader than it is an author. It's not an audience member. It's not responding to the works that it is trained on. So I also don't think that we could or should treat the AI as, when it's trained, as infringing copyright in the works and the training inputs. Works of authorship, again, are communicative acts. So they are intended to generate and communicate feelings and emotions and responses. A machine is not capable of that when it reads and extracts data from the kinds of materials that are involved in text and data mining. These things are being used as things. They're not being used as works of expression. They're being scanned to extract data. And so those uses also do not implicate copyright law. So overall, that's my position. This is a picture of a robot reading a book, which again, I did not create. And my conclusion then is that we need to avoid this kind of romanticization of robots, and we need to be much more attuned to the social costs of granting copyright control or allowing copyright to intervene in this area. And if we're not honest about what it is we're dealing with and what it is we care about, we're going to make some significant policy mistakes that are going to harm rather than advance the public interest in the age of AI. Thank you very much.
Thank you very much, Drs. Carys Craig, and I love your presentation. I've got several questions, like thousands of pages of notes here that I got written down, and I guess I might thought we made a good start. And there is some conversation already happening in the chat, and I might give everybody a chance to kind of react and or ask questions to each other. So make yourself comfortable. Otherwise, I will start.
Well, we've all known each other for a while, so we may have questioned each other out already, but I'd say go for it, Angela.
Okay, we have a questions to Mr. Christian Hannon. I'm not sure you saw in the chat. Is there, but while he's reading, I will start with Dr. Craig. I really love it when you brought us this clarification. Robots are not dancing. They do not know what they are doing. And they are not really dancing at all. And it's really scary to have to say this. Because a lot of people develop feelings for something. People can develop feelings and love for fell in love for an algorithm, for example. I think so. But the algorithm won't develop feelings, no matter how real it looks like. Yeah, and then people tend to romanticize. So for that, I would like to make a link with the earlier presentations. Is it possible to apply the same criteria and critics to an AI that has developed a technique that is submitted for a patent application? So Dr. Hannon and Dr. Ryan Abbott, what do you think about that? And well, Dr. Craig.
Someone else is welcome to start. I mean, first, if you really want to be horrified, it's much less the robots dancing than me dancing. If anything, robots are doing a much better job than I would do. I have a number of issues with the premises Carys is using, although I do fundamentally agree on, it really depends on what you want out of a copyright system, right? And that is something that a society has to select as its values. Do you want more creative works in the marketplace, which is what the US model is, or is authorship something different and relational? For me, back in the day, Carys wouldn't have done this, but Andres, who she cited, used to say he would go through random clip arts and just sort of take other people's pictures and call it fair use. Some of us have done that in the past. Now you have AI making these things. I had an engagement with the photos she picked that was AI made. They had an impact on me to me, if she said I would have been impressed if she'd made them. Plus, she was a law professor. But, whether she made them or a robot made them or Ian's favorite artist made them, I don't know that affected really the way that I engage with that photograph. So sometimes authorship is very relational, but sometimes it really isn't. And I don't think it always needs to be. When you ask about things like, well, why is the robot or the person creative and not the robot, or why is the person dancing and not the robot, we don't really even have a philosophical consensus on what that means. But the law, in my view, also really shouldn't be getting into these philosophical distinctions. It should be utilitarian. Is there a problem? Does the law have a solution to it? Are we better off with the solution? And again, if it's we want more works, then the answer is yes. And if it's we really only want people to be connecting to other people, we don't want them connecting to robots, then maybe no. And I'll just kind of finally toss in, it's an interesting point. Some people do have weird relationships with machines, although maybe in 10 years it won't seem so weird anymore. Some people have weird relationships with other people where they have unrequited feelings. These are complicated things, but I think kind of things that copyright law should be agnostic to.
Okay. Dr. Craig or Dr. Hannon?
Yeah, I don't know, Chris, did you want to go first?
Well, I'll defer to the copyright expert. Please.
Okay. So yeah, and this is a debate that Ryan and I have had before, and I definitely am less of an economic utilitarian than is he, and so that we do have just a different starting point. But there are just a few things or assumptions built into his response that I would quibble with even on their own terms. So first, I don't think I could characterize even in the US the goal of copyright as being more creative works in the marketplace. Because it's not just about more. So the notion that all we want to do is ensure the massive sort of multiplication and proliferation of every single kind of possible work in a marketplace is a focus on the product rather than the process. What I think I would say, and this is sort of drawing on some of Barton Beebe's work in this area, is that certainly the constitutional basis of copyright in the US isn't just concerned with the mass production of works as sort of cultural products that circulate in a marketplace. It's concerned with encouraging authors and rewarding authors, because it's concerned and tapped into the sort of the democratic value, the participatory value of people engaging and creating and learning and sharing. And that's what it's not. So it's not the production of a thing for the thing's sake. It's because the thing is about learning, and it's about culture, and it's about education. And these are, I think, concerns that should add some nuance to the idea that we just want more and more is necessarily better. And the other thing, just in terms of engaging with the works and appreciating the importance of the works and relating to the works, I think that's all clear. I'm not suggesting that we don't see or appreciate the value of the works, that we can't interpret them in their own right, rather than as something that another author or human is trying to tell us. But just because they have that communicative value and we can engage with them, doesn't necessarily mean that we have to make them subject to private proprietary right and give them to somebody. They're valuable, it's wonderful, we're making them anyway, we can all make them. It's democratized the production of wonderful art in an incredible way, and that's great. And these tools are available to us now, and that's wonderful. Again, it doesn't mean that we need to privatize and propertize and commodify the results.
I'll just very quickly. Sorry, Chris, do you want to say something?
No, go ahead, Ryan.
Oh, this is the last thing we say. Right. Well, as Carys pointed out, there's a lot of reasons why you might want to have a copyright system, or a stronger or a weaker copyright system. Various copyright academics have thought that those are purposes for it, even in the US. But in the US model, the Supreme Court has been very clear. We have this to promote dissemination and generation of works. It is in that public interest. It is not for the benefit of authors. The copyright clause is there to promote the progress of science and the useful arts, and it has done this through creating an incentive. But even in the authorship realm, it is often the economic impact it is having on publishers and the dissemination of works, and even more in the copyright context, almost always on investors, capital, and employers than it is on individual inventors. But I mean, it is an interesting question because it really does, to me, get at, well, what do we have a copyright system for? And, is it this or is it the other thing? And it might be that, in one jurisdiction, it's one thing, and in another, it's a different one.
Well, I was just going to chime in to say I'm really glad I'm a patent lawyer, because I don't want to have to deal with the morass that is copyright law and any fair use analysis of any of this stuff. But I will turn to the question that was raised by the audience and just say thank you for the question. And, I think any time that you get into a regulatory framework, you're going to run into some possibility of protectionism, right? So if you think about the relation of data to AI, that has major implications versus being in China versus being in the United States versus being in Europe, right? So Europe has their GDPR, which regulates data to an extent. U.S. has a little bit more, market-based, best practices type of regulation scheme, whereas China, has a more state-driven regulatory framework. So I think there's definitely going to be opportunities for protectionism, and if like I mentioned, the OECD, right, does a lot of work on AI policy. So if there's frameworks in place to create open sharing of this information and even development of artificially intelligent systems, then I think that will go a long way to sort of downplaying the ability to play protectionism roles in policies. But I think the modern state of the world today, we already see that, right? So, there's been some authorship out there about, the rise of China and why did China get a jump start on AI? And the argument was that, well, they have so much data that they acquire through their population that they all use apps for everything under the sun, and anyone can have access to it, and the state can use that to control folks that way, versus having a more market-driven approach in the U.S., right? I think we're setting ourselves up for a good effect and outcome in AI policy. But as Ryan mentioned, right, we just the White House unveiled their Bill of Rights around AI. So there you see things like we are more concerned with democratic values. We want to have more transparency and know if there's biases and ways to stop that. So I think in the long run, we'll get there, but it's necessarily to bring everyone to the table and make sure that we're not doing things that result in protectionism schemes.
Someone else? I am thinking here about what is AI exactly. I'm really a little curious about this. We can consider a lot of outputs, training data, weights to be given to various criteria and models, algorithms, know-how of programmers. But we also need to consider the inputs and the need of large sets of training data. And so I'm thinking here if Davos is working or creating or doing a statistic work using, among other things, data. Yeah. And is that correct that an AI is a program that statistically can give a possible result? If an AI is an algorithm, is a software, I'm not sure it could be protected under the patent law. It looks to be a purely abstract concept, and that is not protected, at least by Brazilian patent law. What do you think about that? Could we really presume what is AI? Is a software? Is an algorithm just that?
Well, it's complicated, but I think the general answer is it's almost always just a math equation, a complicated one. But your comment goes more toward the protectability of the equation, which, the US has some perhaps confusing jurisprudence about whether you can get a software patent. The EU's a bit clearer, whether it's a technical solution to a technical problem that's a computer implemented invention, but not a patent on software per se. And, the US has a test for it. But that is different than an algorithm generating some sort of by itself substantively patentable thing, right? So that goes to the process by which an invention is made. So you might have a math equation coming up with a new chemical compound. The chemical compound itself would be patentable subject matter. It may not be patentable depending on the law of inventorship.
Yeah, and I think that it goes a long way towards just the ability to clearly draft a claim, right? So you can imagine instances where someone just recites that matrix multiplication or something, or some Bayesian statistical outcome, right? That probably under US jurisprudence would not be enough. But if you then start to claim in more physical components and you can showcase something that is beyond just a mental activity of a human being that goes so far beyond that there's no question that it could never be done sort of by paper and pen or something along those lines. It really gets into that claims draftsmanship game to some extent, where how clearly you're claiming it and how much structure and computer embodiments of some specific implementation, that's going to get you closer to having a viable patent claim than not. So I think there is some element of that. Whether or not that's the best case scenario for the system, that's a different question maybe. But I think with the rise of even data rights, if you get away, like you talked about training data, like that is a separate issue probably, which involves some copyright issues as well. But there's been some discussions around the world about maybe we need some sui generis right for protecting trained data sets, and is that something that we should investigate versus just claiming, like I was trying to make that distinguishing set of three criteria in my presentation, right? If we're talking about just the foundational AI, that algorithm, right? That's one thing. But then, like Ryan said, if it's some output of a system, right? That output is probably very clearly being able to be claimed. But then what effect of that data that was used to train that to get that system? Is there any protection that we should give to something like that? I think that's an open question now.
And if I can just maybe add quickly that the algorithm is, of course, a copyright work. And so as literary expression, the algorithm, the AI software would be protected, which is why sometimes I think just even if we accept that we want to encourage the creation of AI to generate, literary, dramatic or musical works, we're already encouraging the creation of the algorithms by allowing copyright to vest in those. As for the training data, I think it's worth flagging as well that there are, you might see my face when you suggested a new sui generis right to protect the text and data going in. I think we have to be very careful about this, because it's very clear that in order to have, one of our concerns is the way that AI is being developed, the way that it's being operationalized, the way that it has implications that, create or exacerbate existing biases in our system. And what we don't want to do is place restrictions on the training of AI to make it less good at what we want it to do. So I actually think trying to create a system that ensures, and that's what I was suggesting, a sort of freedom in terms of the training of the AI, and I'm more concerned then with what comes out and how that's protected, or what we do with it. But I don't think that creating private ownership over the data going in is going to help us. And I think it's really going to hurt us when it comes to things like transparency and accountability and ensuring that there's good representative data on which the AI is being trained.
Yeah, well, just a moment. Okay, we are at the end of this session now. We have just a few minutes, and I am sad because I would like to stay here. I have more questions, but maybe we can have more conversation later. We can meet again, and I hope in presence. I really would like to meet you all in presence here in Brazil, maybe, or somewhere. So thank you very much. I thank you also the audience, and I hope to see you soon. Okay.
Thank you.
Pleasure.
So much.
Thank you.
Bye.
Great to be here.
It's so sad to need to close here, but it's our time where we have a lot of So, okay. So thank you very much.
Thank you so
Bye.
much. Good
Thank
to
you.
see you. Bye.